for your time in joining us. As one of our leading IP firms in China, SPTL has been providing for a range of IP services since 1984. Today, one of our patent attorneys, Mr. Mingxiang Xin, will share with us an interesting topic about tips on leverage of Chinese utility model system. Mingxiang joined SPTL in 2016. His practice in patents involves prosecution, drafting, re-examinations, invalidations, and infringement analysis in the area of machinery manufacturing, equipment, and technology of machining. Today, Mingxiang's presentation will last about 30 minutes. Then we have several minutes for questions and answers. Or please raise your questions through text message during the presentation. Now, let's welcome Mingxiang.
Thank you. Thank you for the introduction, Ms. Hu. Hello, everyone, and thanks again for your attendance today. I am Mingxiang Xin, a patent attorney from Mechanics Business Department at SPTL. And I am very pleased to share with you some tips on how to leverage the Chinese utility model system. More and more of our clients from both domestic and abroad are becoming interested in Chinese utility model protection. And with the latest development of utility model in China, many of them have encountered some problems. Before we get into the specific tips, let's first take a quick look at the number of newly filed and granted patents in the last last year in categories, so as to provide a general picture of how widely the is practiced in China. According to the statistics provided by CNIPA, there has a growing interest to obtain the Chinese for applicants worldwide, and foreign applicants may also make use of the system to obtain a better position in Chinese market. As you can see from the chart on the right of this slide, in the past half year, the number of newly granted Chinese inventions is around 400,000. In contrast, the number of newly granted Chinese is nearly 1.5 million. Also, comparing with the number of applications filed in last year, as shown on the left for a rough estimate, it can be seen that the grant rate of utility models are many times higher than that of inventions. The figures illustrate the fact and may be the cause of the huge interest in utility model from the applicants worldwide. I hope my presentation today would give you a closer look on the Chinese utility model system, which may help you figure out the best way of taking advantage of it. Here are the main sections we would relate to in today's presentation. Firstly, we would discuss how to apply for new Chinese Allow me to read the utility model as for short. Secondly, as a patentee, we would discuss how to enforce our own Chinese Thirdly, we would also turn to how to avoid infringing others' Chinese Then, at the end, I would like to conclude by presenting the key characteristics of Chinese All right, then, first, let's get started with the first section, the tips on applying for Chinese As we know, in the Chinese patent law, it offers 3 types of patents: design, invention, and And it would be useful to clarify the similarities and differences between invention and Although the invention and the are two different types of patent, it may be helpful to clarify at the beginning that the two types of patents share way more similarities than the differences there between. As we can see from the definition of them, both of them are created for claiming protection of new technical solutions. In fact, anything that can be claimed with a application may also be claimed with an invention application. Besides, as long as the patent right is still valid, the Chinese patent law offers exactly the same standard of protection for both of the two patent types. What's more, the novelty and applicability requirement are also exactly the same for both of them. So what indeed are the differences between these two types of patents for new technical solutions? With a closer look on the Chinese patent law, means any new technical solution relating to shape, structure, or their combination of a product, which is fit for practical use. It may be hard to realize its differences from inventions with UM's definition alone, so my pleasure to also share with you the definition of an invention for an intuitive comparison with the definition of Invention means any new technical solution relating to a product, a process, or improvement thereof. By comparing between the two definitions, we may first conclude that a process or a method is not a qualified subject matter for and can only be claimed with an invention application. Moreover, it is to be noted Is there any problems, or can you still see me and hear me clearly? So let's continue. By comparing between the two definitions, we may first conclude that a process or a method is not a qualified subject matter for and can only be claimed with an invention application, as I said before. Moreover, it shall be noted that not all new technical solutions for products can be claimed as a subject matter in Chinese As emphasized in red color here, it is also required that the technical solution claimed in the application is new in its shape or structure, or both shape and structure. For example, a new material with its new mechanical compositions is indeed a new product, but still it cannot be a subject matter of application, but has to be claimed with an invention application. Okay, now we understand what kind of subject matters are suitable to be claimed in application. Let's move on to the filing strategies for applications. And we would mainly focus on the explanation of the potential problems regarding the parallel filing strategy. Generally speaking, for foreign applicants, in order to request for a Chinese there are two options as provided in this slide. The first option is to file a application directly before CNIPA. In this way, the Chinese application can also claim one or more conventional priorities under Paris Convention, so as to benefit the priority rights from one or more previously filed applications. When filing a application in China in this first way, the applicant is allowed to make parallel filings. When referring to parallel filings in China, we mean that the same applicant is allowed to file correlated invention and applications on the same day in China. Often, the application would be examined first and may obtain a patent right earlier, let's say around 3 to 9 months from filing. As long as the is still valid and before the grant of the corresponding invention application. In order to claim the same protection scope by the invention as that in the granted the applicant is allowed to abandon the earlier granted application without having to claim a different protection scope in the invention application. It is to be noted here that according to the latest practice in China, the examination of the corresponding invention application in the parallel filings would usually be delayed for around 3 to 4 years. Therefore, when the applicant wishes an earlier grant of an invention patent, it is recommended to apply for the invention only to avoid the long period of delay. And that's all for the first option. The second option, to use Chinese system for foreign applicants with PCT applications, is to enter the Chinese national phase of a PCT application as a Chinese application, so as to benefit from the advantages of the Chinese system. It shall be noted that the parallel filings are not allowed when entering the Chinese national phase of a PCT application. That is to say, when entering the Chinese national phase of a PCT application, the applicant has to select the application to be protected either as an invention application or as a application. So both two options have almost the same examination process before CNIPA, so that the applicant can select the most suitable one as desired. Okay, now let's move on with the procedure after filing. We need to know that after filing or national phase entry of a Chinese application, it would be subjected to the so-called preliminary examination before being granted a patent right, and it is advisable to get prepared. More specifically speaking, the preliminary examination is now performed by the examiners from the department of CNIPA. It shall be emphasized here that the preliminary examination for a Chinese is not equivalent to the registration for patent applications in some other countries, for example, in Germany. That is to say, in addition to the formal examination on filing documents, such as the specification or other legal documents, and the checking on the payment of various fees, the preliminary examination of a Chinese also concerns examination on obvious substantive deficiencies, as marked in red here and would be detailed later. As mentioned earlier, if a Chinese application fails to overcome the deficiencies raised during preliminary examination, including those obvious substantive deficiencies, the Chinese would not be granted but be rejected. So there is a chance that the applicant may have to deal with substantive issues during preliminary examination of a Chinese Now, in particular, the examination on obvious substantive deficiencies of the application concerns the following aspects. The first one is to examine on the subject matter to be protected, so as to make sure the application is related to shape, construction, or both of them of a product. The second one is the examination on obvious lack of novelty. It is to be noted here that the standard on absolute novelty and the particular way of searching during examination is exactly the same as that in an invention application, which means that the examiner is allowed to perform a search to find one conflicting application or one prior art document which discloses the technical solution claimed in the claims. Other aspects include, for example, the practicability or applicability of the claimed technical solutions, the unity between the claims, or the clearness, conciseness of the application documents, etc. Preliminary examinations major difference from the examination of an invention application now is that it skips the examination on the inventiveness. As a result of the unintended inventiveness requirements during preliminary examination, there could be quite many granted and valid that do not meet the requirements of inventiveness, as there would be no examination in this aspect before its grounds. Please kindly be informed that although the current practice does not allow the examiner to reject a application due to lacking of the inventive step, according to a new piece of official news last month, CNIPA is now studying on the examination of obvious lack of the inventive step during preliminary examination, which may bring great changes to the utility model system in China. However, since the revised regulations have not been officially settled yet, it's better to wait and pay close attention to the newest changes in the near future. And that's all for the issues of preliminary examination of the applications. Based on the above discussion, we know that the examination of a application indeed relates to quite many substantive issues. So it is largely different from the registration system and need the applicant to get prepared before filing, especially by paying special attention to the drafting quality, which at least, as we say, cannot be lowered in comparison with those invention applications. Okay, let's continue and suppose we now have successfully obtained one or more Chinese patent rights. How shall we, as a patentee, to enforce the patent right of a Chinese It is firstly to be noted that a Chinese can offer the same value as a Chinese invention. According to Chinese patent law, after the grant of the patent rights for generally speaking, no party may, without the authorization of the patentee, manufacture, use, offer to sell, or import the product patented for production or business purposes. It is to be restated here that the specific right of a patentee would be exactly identical if the same solution is protected with an invention patent. When an infringer fails to follow the requirements of the patentee, there are basically two approaches for the patentee, as shown in this slide, to enforce the rights protected by Chinese patent law, which is similar also to an invention patent, which is to say, we may either choose to directly file a lawsuit before the court for injunction or composition, or we may ask for administrative injunction from the Administrative Authority for Patent Affairs. A question may be raised at this point that since does not undergo the examination on inventiveness during its preliminary examination process, and many of the granted do not comply with the inventiveness requirements, then why the patent law offers the right of the patentee to enforce a patent right with potential substantive deficiencies? This question would lead to an introduction of the patent evaluation report regime for Chinese patents. So this would lead to our next tip on how to enforce Chinese which is to know and to use the patent evaluation report. The patent evaluation report, PER, is a report on the patentability of a granted patent provided by CNIPA upon request by relevant parties. So who can and when can we file a request for the PER? Basically, according to the current practice, the patentee or any interested party can file the request for PER. When we mention interested party here, we refer to those who have right to file a lawsuit before the court, such as licensee of exclusive patent license contract, licensee of common patent license contract who has been authorized by the patentee. What's more, according to the latest revised version of the patent law, during the process of a dispute on possible infringement, the alleged infringer can also present a PER. Although the related regulations have not been settled and published yet, according to our latest practice, the potential infringer being sued or having a warning letter at hand may also request for the PER. And at present, the qualified party, as just mentioned, may only request for PER after has granted a patent right. And according to Chinese patent law, the PER shall be issued within 2 months from the acceptance of the PER request. It shall be noted that no matter how many PER requests for one are filed, only one report would be issued. Also, since the PER is deemed as a piece of information provided by administrative authorities for reference, if any party who filed the PER request is not satisfied with the content or conclusion of the PER, it cannot be sued, but only a request for correction on obvious errors may be filed within 2 months from the receipt of the report, which is to say, if the CNIPA refuses to correct an unsatisfactory report, the patentee or any interested party has no way to change or remove the report, but only let the report remain access to the public. As an evaluation report made by CNIPA, the PER of a patent may at least have the following functions. Firstly, it allows anyone to review and copy the PER once it is issued. With a positive results, the PER may be an evidence to prove the steadiness of the patent. With negative results, the search results and remarks therein may be helpful for any petitioner willing to invalidate the patent. Secondly, a negative PER may be one of the reasons for suspending a lawsuit before the court. Thirdly, according to the latest practice, a PER is always needed for administrative enforcement may be considered by the administrative authority or for the acceptance of a lawsuit by the court. Lastly, it is also required for customs protection to be considered by the local customs office. However, as mentioned above, the issuance of a PER with negative results even does not mean the invalidation of a granted patent right. A separate invalidation process is still required so as to invalidate the patent. Otherwise, the court would also consider the patent right as being valid. With so many functions of PR, there seems now is an increasing number of PR requests being submitted. And CNIPA usually need more than 1 month before completing and issuing a PR. Therefore, if required, it would be advisable to file the PR request as early as possible. As the PR would also evaluate the inventiveness of a patent, we would now like to point out that the standard on inventiveness is another difference between and invention. So shall we turn our attention to the inventiveness requirement of in comparison with that of the invention? According to the provision of Chinese patent law, in order to be inventive, an invention patent shall have prominent substantive features and represent notable progress, while a patent shall have substantive features which may not be prominent and represent progress which may not be notable. From the different wording in the patent law, it can be inferred that the law is provided to lower the inventive standard for in comparison with invention. But the question is how to realize such a difference in practice. Generally speaking, when assessing the inventiveness of a claim that has one or more distinctions from the closest prior art, it is important to explain on the technical suggestion or hint to implement these distinctions in the closest prior art. In this regard, the different standards for inventiveness examination of a and an invention mainly lie in that there is a limitation on the evidences used to prove the technical suggestion or hint, which motivates the skilled in the art to modify the closest prior art as defined in current claims. As illustrated in the table of this slide, there are mainly two aspects of limitations to the source of such evidences. The first aspect is that when assessing the inventiveness of an invention, evidences for technical hint may come from identical field, close and related field, and other field that is urged to refer to. However, when it comes to usually only identical field and close and related field that is urged to refer to can be used. The second aspect is that the number of evidences is limited when assessing the inventiveness of a Usually, no more than 2 pieces of evidence shall be used to prove the technical hint for a So with these 2 limitations, it could be harder to provide the technical suggestion or hint for any distinctive technical features. According to certain instances, these limitations may indeed make a big difference when assessing the inventiveness of a and an invention. From the above said, the applicant or the patentee may make full use of the lower requirements for so as to claim protection or to study their granted patent rights for certain new technical solutions. All right. The above is all about the issues on how to obtain a patent right as an applicant and how to enforce the same as a patentee. Now, we shall switch our position, i.e., how shall we avoid infringement on others' Chinese as a competent entity in the Chinese market? We understand that due to the enormous number of valid patent rights during an FTO for Chinese markets, it is rather likely to find relevant that may be a risk for us to implement the desired product. What's more, a large number of these valid UN patent rights seem easy to invalidate. But our first tip would be paying attention to the risk of infringing any valid Chinese UN. First of all, we would suggest do not neglect the risk of potential infringement, even with high confidence on the success in invalidation of a UN patent right. As mentioned earlier, even with a rather negative PER, any valid UN patent right is in any case a valid patent right if we are sure that our future products would fall into the protection scope of a valid UN. The implementation of the same would be a violation of the patent law and would tend to put ourselves into a disadvantageous or passive position. According to the record, in certain reported cases of infringement of a UN patent right, the amount of compensation ruled by the judgment can be up to tens of millions of Chinese yuan, which is equivalent to over 1.6 million US dollars. What is recommended is that we lay equivalent emphasis on the risk of infringing the relevant UN as the risk of infringing others' valid invention. For example, usually, before we take further actions, we may check the current status of the concerning UN to see if it is still valid. If valid, we may try to design around the concerning UN so that our product may not fall into the protection scope of the patent right. In addition, or as an alternative, we may perform an analysis on the stability of the concerned UN, in particular for those claims that may affect our production, to see if it is possible to invalidate the concerned in claims. Of course, matters like negotiations can also be done as another step to take. If we want to implement the product as defined in a valid patent, it would be highly recommended that we file a request for invalidation before the re-examination department and only proceed to implementing the interested product after the relevant claims have been declared as being invalid. Lastly, there is another tip for coping with a granted UN if it is one of the applications in a parallel filing. Which is to say, when we need to invalidate a valid UN patent, we may first check if there is a correlated pending invention application, and we may submit third-party opinions against the parallel pending invention application. And there is the case when we may need to invalidate a UN of a parallel filing while the correlated invention application is still pending. In this case, instead of requesting for invalidation directly against the granted UN, we may turn to submit third-party opinions against the pending invention application, so as to urge the applicant to deviate the protection scope from our intended product. Once such a purpose is successfully realized on the patent invention application, we may take a better position either in a subsequent negotiation or invalidation process of the broader scope as granted in the UN, since it would be rather hard for the patentee to insist on the patentability of the broader scope later due to the so-called estoppel requirements. A particularly unique advantage of filing third-party opinions is that the applicant of the invention, which is the patentee of the UN, would not know if there is or who is the one that are against their patent applications. So we may not need to come out until necessary. This would be quite useful when we prefer to be hide behind and do not want the competitor to know who we are. Okay, bearing the above discussion in mind, I would like to finish my presentation today by concluding on several key characteristics of Chinese which may help to figure out how to adapt it to your own interest. The first feature is a major advantage of Chinese the prosecution period of a Chinese would be a lot shorter than most invention applications, which may meet the requirement of obtaining a patent right faster. Also, its preliminary examination covers many substantial deficiencies except for the inventiveness, at least for now, which may provide a relatively stable patent right with respect to the registration system. Therefore, the Chinese would always be welcomed if a quick ground is desired. Secondly, as said before, the requirement on the inventive step is lower for a application than for an invention application. In this case, may also be suitable for new products with relatively small inventive steps. Also, the overall cost for obtaining a patent right would be lower than an invention patent, so that the patentee could obtain more patents in its patent pool with a limited budget. And next, regarding the protection period of a maximum of 10 years in comparison with 20 years, which is for a patent, it seems that such a 10 years protection period for a is rather reasonable and widely accepted for new technical solutions to be practiced in this vast changing Chinese market. Therefore, may also be suitable for the products with rather short life cycle. Last but not least, as said in the beginning, the invention and as two types of patents for new technical solutions share more similarities than their differences. The most important similarity is that the has the same standard of infringement judgment as an invention, in aspects such as the amount of compensation, the interpretation on protection scope, the rule for infringement determination, etc. So that the applicant may enjoy the same level of protection with a lower cost. But on the other hand, as also mentioned before, if our new technical solution relates to a method or a process, in order to utilize the system, it may be necessary for us to try to adapt it into a product claim, for example, during drafting before filing. Also, the skip of the examination on the inventiveness would largely reduce the chances for amendments during prosecution. So it would be advisable that more attention shall be paid to the drafting quality before filing, so as to obtain a stable patent right. As said at the start of this presentation, more and more applicants worldwide tend to show interest on the Chinese system. And I hope this short conclusion, as well as my presentation today, would help you understand how does the system works here in China, so as to help you avoid possible problem in practicing Chinese and figure out a best way to leverage the system. So that is the end of my presentation today. Thanks for listening. And now I'm willing to answer your questions.
Well done. Thanks for your sharing, Mingxiang. Now let's go to the question and answer session. Here's the first question is from Miss Jo Wright. The question is it necessary or what's the reason to provide the utility model system in China, since the subject matter can also be claimed in an invention? Is it only beneficial for patentees? Mingxiang, please.
Thank you. Thank you for your question, Ms. Jill Wright. Let's say at the very beginning of establishing the Chinese patent system, the utility model patent right was provided as one type of the patent rights for encouraging the IP innovators to protect small improvements to the shape and or the structure of a product. So at that time, the examiners usually would not perform search work beforehand, but would examine the novelty based on the available prior art information from, for example, the description of the application. So, and at that time, there would also be no available process for obtaining a PR from the CPO. Nowadays, in order for improving the quality of the patent rights and with the amendment on a guideline to examination, and the examiners would do search work if they deem it necessary. In addition, when the patentee needs to enforce the patent rights, usually a PR issued by the patent office upon request shall be provided before the court, the custom, or the administrative authority. Sometimes during the process of an assignment, a PR may also be required by the assignee to evaluate on the inventiveness or the stability of the patent to be assigned. Let's say, based on our practice, if a maximum protection period of 10 years for a new product is enough to satisfy our needs, and a draft with good quality could be obtained, the system may be a suitable strategy appealing to applicants worldwide, which might be the reason that besides domestic applicants, more and more foreign applicants are applying also for Chinese applications. In addition, as I mentioned during the presentation, for the same invention, since the inventiveness requirements on the is lower than the invention, so it may be more stable for the same technical solution during the invalidation process for patent product. Okay, that's my answer for this question.
Okay, the second question is from Mr. David Robinson. The question is, if during the course of an FTO, find a highly relevant patent right, but have high confidence the right should not be allowed, what weight shall we place on this patent right?
Yes. Thank you for your question, Mr. David Robinson. We understand that it is a common situation that might be encountered. So let's say upon spotting any that may be a risk for you, it is recommended to perform an assessment on the validity of the concerned Chinese first. If there is high possibility that the concerned claims can be invalidated in the Chinese practice, you may choose either to secure the prior evidences or to file a request for invalidation before implementing the patent in China. However, if there is a risk that the concerned claims may maintain valid against the available prior evidences, it is highly recommended that you consider, you reconsider the implementation of the same product in China before the concerned claims are being validated. What's more, when facing any invalid UN patent rights, we may also check if there is a correlated invention application that was submitted with a parallel filing strategy and it is still pending. And we may submit third-party opinions to the pending invention application, which may force the applicant of the invention, which is so that he can limit the protection scope in the pending invention application. Thank you.
Okay, thank you, Mingxiang. At this moment, it seems there's no further questions. Anyway, if anyone has further questions, please send your questions by email. This comes to the end of our webinar today. I hope the information just provided will be helpful to you and your clients. Thank you again for being with us. Our next webinar will be hosted in September, so stay tuned. Have a good day. Good night. Bye-bye.